Critics of third-party litigation funding often cite an ancient legal principle to support their contention that such funding should be prohibited. This principle has a medieval name, champerty, and has often been used to stop plaintiffs from getting help from third parties. But more than 50 years ago, the Supreme Court held that this principle cannot be used to stop serious efforts to achieve justice. In the early 1960s, Virginia enacted a law that prohibited improper solicitation of legal or professional business. The statute was drawn broadly enough so that it was unlawful for civil rights groups to help plaintiffs, for example, who sought to bring lawsuits fighting various forms of racial segregation. The NAACP sued, arguing that this statute was an unconstitutional infringement on political action. Virginia responded by arguing that the common law had long supported prohibitions on any attempt to encourage parties to file or continue litigation, regardless of the purpose of that litigation. According to the state's lawyers, the statute was within the well-established tradition of banning champerty. However, the Supreme Court agreed with the NAACP. In his majority opinion, Justice William Brennan pointed out that association for litigation may be the most effective form of political association for minority groups and others who are facing various forms of government or social oppression. And he ruled that a state may not, under the guise of prohibiting professional misconduct, ignore constitutional rights. Thus, speaking for the court, he concluded that we hold that the activities of the NAACP are protected by the First and 14th Amendments, which Virginia may not prohibit under its power to regulate the legal profession. Of course, the fight for justice can take many forms in addition to the struggle to ban racial segregation. Many plaintiffs have been the victims of unfair social or economic arrangements, and they can find justice only by suing. When litigation financing promotes justice in this way, it comes within a legal tradition whose validity has been confirmed by the United States Supreme Court. If you need help with litigation funding, call or email me today.